Good afternoon, and welcome to the second day of the Tanner Lectures on Human Values, featuring my friend and colleague, James Forman, Jr. From Yale Law School. I am Carol Steiker. I'm on the faculty here at Harvard Law School. And before entering the Legal Academy, almost 35 years ago now, I worked for several years as a public defender. Why do I tell you this? Well, partly it's because that experience was so profoundly formative of the way I think about the world. Last week, I spoke at Simon Peirce Law School in New Hampshire and had dinner afterwards with a former student who is now the head public defender of the state of New Hampshire. And I came home and I said to my husband, I just love public defenders. Of course, like any large group, public defenders are a varied bunch, but they generally tend toward and cultivate deep compassion for human suffering, righteous indignation at injustice, and a strong commitment to human equality. But, general admiration aside, the main reason I am banging on about public defenders is that both of our speakers today started their careers as public defenders. So folks, for better or worse, it is Public Defender Hour here at Payne Hall today. Obviously, I think it is for better, but let me tell you, these are no ordinary public defenders. It is a very great honor to introduce this year's Tanner Lecturer, Professor James Forman, Jr., and today's respondent, my beloved colleague and friend, Professor Alexandra Natapoff. Let me start with Professor Forman, who is currently the J. Skelly Wright Professor of Law at Yale Law School. After attending Brown University and Yale Law School, he spent 6 years at the Public Defender Service for the District of Columbia, where he represented both juveniles and adults charged with crimes. During his time as a public defender, Professor Forman became frustrated with the lack of education and job training opportunities for his clients. So in 1997, he, along with another former public defender, founded the Maya Angelou School, an alternative school for school dropouts and youth who had been arrested. In the decades since its founding, the Maya Angelou School has expanded to run multiple schools inside DC's youth and adult prisons. Its success was chronicled in the 2023 short documentary film, Welcome to School. Professor Forman's scholarship focuses on schools, police, and prisons, particularly the race and class dimensions of those institutions. Professor Forman's first book, Locking Up Our Own, Criminal Punishment in Black America, was named one of the New York Times 10 Best Books of 2017 and was awarded the 2018 Pulitzer Prize for General Nonfiction. His second book, an anthology co-edited with two other former public defenders, Dismantling Mass Incarceration, A Handbook for Change, was published in 2024. In 2022, Professor Forman helped launch the Yale Law and Racial Justice Center, which brings together New Haveners, Yale Law students, staff, and faculty, local government officials, and local and national experts to imagine and implement projects advancing racial justice. Professor Forman is an elected member of the American Law Institute, the American Academy of Arts and Sciences, and the American Philosophical Society, and he is a trustee of the Council on Criminal Justice. Those lucky enough to have been here yesterday for Professor Forman's first Tanner lecture learned about Professor Forman's innovative Access to Law School initiative at Yale Law School, a novel experiment in legal education in which Yale Law students are paired with New Haven residents from underrepresented groups who aspire to become lawyers. The program offers intensive LSAT prep, coaching through the law school application and financial aid process, and substantive preparation for the law school curriculum. To date, the program has had 49 fellows admitted to a wide swath of law schools, including 3 at Yale Law School. Today's Tanner lecture will address the constitutional legality and thus political viability at this fraught moment of such programs such as these that seek to ensure wider access to higher education. After Professor Forman's presentation today, we will hear from Professor Alexandra Natapoff. She is also an award-winning legal scholar and criminal justice expert. Professor Natapoff began her career as a public defender in the Federal Public Defender's Office in Baltimore, Maryland. She then joined the Legal Academy, where she writes about criminal courts, public defense, plea bargaining, wrongful convictions, and race and inequality in the criminal system. Her book, Punishment Without Crime: How Our Massive Misdemeanor System Traps the Innocent and Makes America More Unequal, reveals the powerful influence that misdemeanors exert within the U.S. criminal system. Her first book, Snitching, great title, Criminal Informants and the Erosion of American Justice, won the American Bar Association's Silver Gavel Award honorable mention for books. Her original work on criminal informants has made her an international expert. Professor Natapoff is a graduate of Yale University and Stanford Law School. She's an elected member of the American Law Institute and was a 2016 Guggenheim Fellow. She has testified before Congress and numerous state legislative bodies, and her work appears frequently in judicial opinions and in the national media. After Professor Forman's Tanner Lecture, Professor Natapoff will offer a brief response, and then the two of them will have a more informal conversation with an opportunity for questions from all of you. Please join me in welcoming Professor James Forman, Jr. to the podium.
Thank you, Carol, for that warm and kind introduction. And I want to thank you, Sasha, or officially Professor Natapoff, for offering commentary. I want to thank the Tanner Committee. I thanked y'all yesterday, but not enough thanks are in order for the group that decided to invite me to give these lectures. I really do appreciate it. It's been an honor. And I also want to thank my research assistant, Mariah Smith, who's here, who came up from New Haven, very kind. She surprised me. She's responsible for none of the mistakes that I might make, but she is responsible for many things that I get right, including the slides. So thank you, Mariah. I really appreciate it. To those of you who were here yesterday and came back, thank you and welcome back. If you weren't here yesterday, thank you also for coming and welcome. Yesterday in my lecture, I called for universities to aspire to become engines of social mobility. And I spoke about the Access to Law program as an example of what that work might look like. And I hope I persuaded some of you. And even if I did, you might still be thinking, well, okay, that might have been a good idea, but it's not going anywhere now. What about the Supreme Court's decision in SFFA and the Harvard and UNC cases cutting back on affirmative action? What about the Trump administration's aggressive efforts to combat anything that purports to advance diversity and inclusion? I mean, in light of all of this, you might be wondering, can an effort like this or others like it survive? And my short answer is yes. Yes, it can. A program like ours is legal and consistent with Supreme Court precedent, even the more recent precedent that I don't agree with. But today, I want to give you a longer answer to that question because so much is at stake. And because many institutions, unfortunately, are acting as if they are helpless, are acting as if they cannot continue these efforts. A lot of universities are doing what Tim Snyder, the scholar of authoritarianism, who was my colleague at Yale and has since moved to Toronto, he calls it surrendering in advance. And I don't think we should let them. I think if we do, we could easily go back to the 1950s, where there's essentially no people of color at most universities in America. But that doesn't have to be our future. We have the tools to avoid that outcome, and today I want to talk about some of those tools. But I want to do more than that, because if we're going to meet this moment, we have to acknowledge that we're going to have to change some of the frames that we have used to understand racial justice and injustice in America. In his commentary yesterday, Professor Guy Uriel Charles pointed out how racial diversity, that framing, has served as an organizing principle and objective. He used the word telos, but I'm not as fancy as him, so I'll say objective, for universities over the past 50 years. Right? If you wanted the university to have a mission, racial diversity was often a core component of how you frame the claim of what we're doing here, other than all being together in a room reading books. But now that we've been told that frame raises constitutional problems, what do we replace it with? And so to answer that question, the first person that I want to bring into the conversation is, for me anyway, an unlikely one. I think this is the first talk that I've had where I've had a slide of Justice Scalia. So Justice Scalia was no friend of affirmative action. But to get into this conversation about what we might do today, I think it makes sense to look at what he wrote in 1979. Right? This was before he was on the Supreme Court. He was a professor. The Supreme Court had just decided the case of Bakke versus Board of Regents. Now, Bakke was the first affirmative action case. It was the one that set the rules that governed for 50 years until SFFA. And in his opinion, in Bakke, Justice Powell had written that universities could use race as a plus factor to advance diversity in the classroom. And Justice Scalia thought that was hogwash. Right? He opposed considering race at all. Right? What did he say universities could consider? According to Justice Scalia, they could look at economic background. They could look at poverty, similar disadvantage. In fact, he said he strongly favored such programs. Okay, but what if a lot of the people who end up benefiting from those programs are people of color? What if a lot of the people are minorities? Justice Scalia said, fine by me. He said it may be that most of the people who benefit from such programs are minorities. Today we might use the term people of color. He said, I wouldn't care if all of them were. The problem, he said, was using race as a criteria. That, for him, was an unacceptable vice. So Justice Scalia is writing almost a half century ago. But during the oral arguments in SFFA, the justices appeared to agree with what he wrote then, that class measures were perfectly acceptable. I want you to listen. I'm going to play a little clip of back and forth between the attorney for the lawyer challenging affirmative action in SFFA, Patrick Strawbridge, and Chief Justice Roberts, another longtime opponent of race-based affirmative action. And Justice Roberts, Chief Justice, had jumped in to distinguish race-based affirmative action programs from facially race-neutral ones. including, you'll hear Justice Roberts refer to, programs that reserve spots for the top percentage of each graduating class, or that give preference to students who are from underperforming schools.
Given that they're race neutral, most of them would not be defended as for race alone. Well, for example, socioeconomic status, maybe attendance at a particular school that's known to be.
Correct. All of the race neutral alternatives, and specifically the socioeconomic benefits and the top percentage programs, those can be justified on race neutral means they increase socioeconomic diversity, they ensure that people in under-resourced schools have an opportunity to attend the university, they create geographic diversity.
Why is the question?
Okay, so that's the oral argument. So we have Justice Scalia from 1979. We have the oral arguments. You might say, okay, but what about the opinions in SFFA? Well, the justices made it clear there that they agreed with Justice Scalia and with what you just heard in the audio clip that I played. Justices Kavanaugh and Gorsuch went out of their way, writing separately, to say that universities and governments can address discrimination and its legacy as long as they use means that don't involve racial classification. So here's Justice Gorsuch, a Harvard Law graduate. And yesterday in our conversation after the lecture, I talked about the sort of admissions preferences currently in place at universities. In fact, Professor Steichen and I had a wonderful exchange that we will long remember when I was talking about that. And I pointed out that the most powerful preferences that we currently have in place are for athletes, donors, and faculty children. Now, Justice Gorsuch was aware of this, and he made the point in his opinion. He said that if you give low-income students just half the admission boost that we give to those groups, Harvard could retain its racial diversity at the same time as it became more economically diverse. Now look, in spending all of this time discussing the conservative justices, I don't want to suggest that I agree with their reasoning in striking down race-based affirmative action. I don't. But I'm also not going to let my disagreement keep me from exploring the path that the court has laid out. Because I'm here to argue that those of us who want to mitigate the damage caused by SFFA have tools available. And in order to do that, we have to begin to develop a new language. Remember, we spent 50 years perfecting, working on, getting used to the old language. We're going to have to develop a new language and a new set of practices and policies to implement, give life to that language. All right, so what can universities do if what we've come to know as affirmative action is no longer allowed? Well, the first thing I think is to set a worthy, ambitious goal. You know, most universities have admission statements. Most of them are so boring and anodyne that you will forget them as soon as you finish reading. I'm on the Yale faculty. I couldn't tell you the Yale admission statement. I mean, I've looked at it, but I've forgotten it. So I want to suggest that universities begin to do something more striking by putting in their mission statements an intention for theirs to be a university that looks like America. All right, let's talk a little bit about what that could look like. Those of you that were here for yesterday's lecture, you will remember this slide. This shows the proportion of American law students based on the education and income of their parents. And as you see, it's dramatically skewed towards the elite, with more law students coming from the most privileged 10% of America than from the entire bottom 75%. And I put bottom in quotes because, right, this isn't the bottom, it's most of America. This statistic is from law schools, but the same numbers hold true for colleges and universities as well. Well, what if the university set a different goal? What if the university said, well, we're going to try to have this distribution, with 25% of the students coming from the most privileged 25% of American families. Currently, 67% come from that most privileged 25%. 25% coming from the next quarter, which is currently 17%. 25% from the next quarter, currently 11%. And 25% coming from the least privileged quarter, which would be up from 5%. Now look, shifts of this magnitude are not going to happen quickly. They're not going to be the result of a single change in policy. So I want to discuss, for the balance of this lecture, I want to discuss two big ways, two things that universities can do to move in this direction, to move meaningfully in the direction of this slide. But before I do that, I want to just note some smaller steps that some colleges and universities have begun to experiment with since SFFA to increase access to low-income and first-generation students. So, beginning with Colorado, 5 states have banned legacy preferences. In fact, yesterday when we were having this conversation and I asked people what did they think their most powerful preference was, and a bunch of people shouted out legacy, and it is a powerful preference in the admissions process. It's not quite as powerful as for athletes and for children of faculty and for children of big donors, but it is powerful. And 5 states have recognized that it doesn't make sense, that it further contributes to the maldistribution and concentration of the elite, and have banned it. Hundreds of colleges and universities have done the same. Shamefully, I must say that the university that I graduated from for college has not banned legacy preferences. That would be Brown. The university I teach has not banned legacy preferences. That would be Yale. And the university where I stand has not banned legacy preferences. That would be Harvard. South Carolina, Tennessee, and Wisconsin have all, remember that back and forth between Justice Roberts and the attorney, they have followed Texas's lead in setting aside spaces for the top 10% of each high school class. Right? Because of residential segregation, our schools are segregated. And that means that if you set aside the top 10% in each class, that has the effect of increasing the representation of low-income and minority students at your university. Finally, some schools have increased the number of students eligible for Pell Grants, which are scholarships reserved for middle and lower income students. So I endorse all of those efforts that I just described, but they're not going to be enough by themselves. We know this because despite these efforts, highly selective institutions remain bastions of wealth and privilege. And in fact, in the last 5 years, the proportion of students from the wealthiest neighborhoods in America has increased at highly selective schools. So the problem is getting worse. Okay, so let's talk a little bit more about what can be done. So drawing in part on these books, by the way, for those of you who are students and you want your reading list, I know that's just what you want is more to read. This is the beginning of your reading list, right here. But drawing on works by Cheryl Cashin, my former colleague at Georgetown, Justin Driver, my colleague now at Yale, Richard Kallenberg, and some of my own experiences in life and work that I've done in Access, I want to discuss these two ideas. So you've probably heard the phrase, your zip code shouldn't be your destiny, right? But too often it is. Now you may know this intuitively, okay? If you're a parent, you likely thought about this when you bought a house. If you're a student, your parents probably did before you were born or when you were young. Right? Many parents do everything in their power to afford a home in the most affluent community they can afford. And that intuition is backed by mountains of research. Right? One of the most frequent findings in the sociology of urban poverty is the persistence of poverty across generations can be tied to lack of opportunities found in poor, segregated urban neighborhoods. And this lack of opportunity often has a racial dimension. Right? Because of historical discrimination, 84% of black children born between 1955 and 1970 were raised in high disadvantaged neighborhoods, compared to just 5% of white children. And those numbers have remained largely constant since that first set of findings. Now today, because of better and more precise data, it's possible to map disadvantage and opportunity almost down to a micro level, right down to particular neighborhoods, particular census tracts. And there's no legal obstacle to giving preferences to students who have overcome the challenge of growing up in low opportunity neighborhoods. In fact, we do this in the Access to Law program that I discussed yesterday. Right? I want to show you what it looks like visually so you can think about how this might work where you live. So this is a map of New Haven, with each pin representing the address of one of our fellows. Now the map displays New Haven and the towns immediately around it. The lighter color on this map refers to lower opportunity neighborhoods. So the lighter the color, the lower opportunity for the neighborhood. Now as you can see, much of New Haven, and especially where our fellows live, show up in that light color, right? Low or very low opportunity neighborhoods. Now, for this map, the neighborhoods are characterized based on rankings from a local nonprofit called the Open Communities Alliance, which puts these maps together for Connecticut. And to formulate the rankings of the different neighborhoods, they use indicators like poverty rate and crime rate and employment rate and home ownership rate. Note that they don't use the racial composition of the neighborhood. So this is not a racial classification. But because of what we know about American history, including a little bit which I'm going to talk about in a few minutes, there's a high correlation between the indicators they do use and race. And this is from Connecticut, but nationally, the Opportunity Atlas, started right here at Harvard, does something similar. So you can go to Opportunity Atlas, not right now, but later, go to Opportunity Atlas, and you can put any address in the country into that atlas, and you can begin to learn something about its opportunity ranking. So the fellows in our program disproportionately come from low or very low opportunity neighborhoods. In fact, the median fellow in each of our cohorts comes from one of those low or very low opportunity neighborhoods. Now, these neighborhoods are full of people with energy and drive, people who care about their neighbors and who are devoted to their children. But they are also neighborhoods where, because of the history I've only touched on, it's harder to find material success. So I'm suggesting that university admissions do what we do in Access to Law and prioritize and privilege people from low or very low opportunity neighborhoods. And remember, I want to be clear about this. There's zero legal limitation to this, including to the scale. Harvard or Yale or any university could say, we're so determined to be an engine of mobility and access, we want to be a school where 30% of the students or 40% or 50% or 100% come from low or very low opportunity backgrounds. They could even call it a quota. Now, some of you are looking at me strange, and I just want to make sure you know, the whole reason the quota is a problem is not because there's anything wrong with setting a set target number. It's because of its association with race. Let me offer an additional thought. Many universities could provide an extra boost to students from low opportunity neighborhoods that are adjacent to or near the university itself. All across the country, we have lavishly wealthy universities that are proximate to communities lacking financial resources. Some of them, like where I teach, or Columbia, or University of Pennsylvania, University of Southern California, University of Chicago, immediately neighbor or are located in the middle of low-income communities. Others like Duke, Northwestern, Washington University, and St. Louis are not far from poor neighborhoods. And all these schools, I argue, should provide this special boost for many reasons, but let me just mention one, is that these schools have a particular obligation to their neighboring communities because they are tax-exempt institutions and have enormous footprints, which means they take large swaths of property off the taxable rolls and they shrink the tax base. So the cities and towns that they're in have less money to spend on schools and local projects. Where I live in New Haven, half the land is not taxable to the city, because it's owned by Yale, which is tax exempt. So that's less money that the city has to support its schools, to support its after-school programs, to support its parks. Providing an admissions boost for residents from nearby disadvantaged neighborhoods is not going to by itself fill the hole left by a diminished tax base, but it's an important step. All right, let me talk about the second idea that I want to put out on the table here, which is family wealth. So far, I've talked about income and I've talked about neighborhood disadvantage, but I haven't spoken specifically about wealth. And it's a common oversight. When we talk about class or disadvantage in this country, which we don't talk about enough, but when we talk about it, we almost always talk about income. But this misses a crucial point, which is that family wealth is a powerful and often stronger predictor of educational outcome than family income alone. Okay, what do I mean by wealth? Here I'm talking about a family's accumulated assets. Think the value of your home. If you're a student, think about the value of your parents' home. Think about your retirement savings and any other savings you might have, stocks, bonds, checking account, savings account. That's wealth when you add that all up together. I first learned about the tight connection between wealth and educational opportunity almost 30 years ago. Okay, here's your second reading assignment. Jackson, are you taking notes? Yeah. All right. These two books, I first came across these books almost 30 years ago in the late 90s. They really rocked my world. Black Wealth, White Wealth by Melvin Oliver and Thomas Shapiro, and Being in the Black, Living in the Red by Dalton Conley. And these books have now, they were path-breaking, but they've launched a generation of research built on those initial findings. And these studies establish that increased wealth is consistently associated with higher rates of high school graduation, a better chance of being admitted to college, especially more elite colleges, and a greater likelihood of graduating from college. So yes, the size of parents' paycheck matters to a child's future. But what matters more is the value of the family home and the size of the parent's bank account. Now, why is this? Why is wealth so much more powerful than income? Well, first, it determines where families can live, right? Even if families have similar income, the one with greater wealth can afford a larger down payment. And that more expensive home is almost certainly more likely to be in a neighborhood with better resourced schools, parks, and libraries. The second reason is that wealth enables long-term investments in children. Private tutoring, test preparation, academic enrichment activities. And the third is that wealth offers a sense of well-being, which children absorb. Families with assets know that they have a cushion against economic shock. They know they can tap their resources to buy critical advantages for their children, including paying for college education. Now, the children absorb these expectations over time. And these dynamics are crucial to the racial wealth gap. Because even among families with similar incomes, Black families typically possess a fraction of the wealth held by white families, a disparity that's rooted in historical discrimination. Right? Wealth inequality, I should say, results from centuries of policies and practices such as slavery, Jim Crow, exclusion from the New Deal, discriminatory housing and credit markets, and unequal access to home ownership and inheritance. And because wealth accumulates over generations and across generations, wealth disparities grow over those same generations. You know, I told you I learned about the power of wealth and its racial dimension when I encountered these books in the 90s. But that's only part of the story. Because at the same time as I was reading Conley, Oliver, and Shapiro, I was having my own direct and personal connection to the words on these pages. When I was a young public defender in Washington, D.C., as you heard from Carol, Professor Steicher, and I began to dream of buying a house. And my meager salary did not allow me to make the monthly mortgage payments in most D.C. neighborhoods, but there were a few that I could afford. My challenge was the down payment. I had saved a few $1,000s, but I was well short of the $25,000 that I needed. So where do you think I could turn? Like many people, I wondered and hoped if my parents could help. Those of you who were here yesterday heard me talk a little bit about my parents. I introduced them in more detail then. I will only say now that right now, this is who they are. And they divorced when I was 7. But they both remained a presence in my life. And they both wanted to help me afford the house. History would have its say about whether they could. My mother's parents came to this country from England in the 1940s, making their way to Oakland, California. My mom's parents found an open, welcome housing market. Well, I should say open to them. Because back then, many houses had what were called restrictive covenants. It's provisions that are put on the deed of the house that say this house can't be sold to a black person, or in some places to Asians or to Jews. Now, the Supreme Court held these restrictive covenants unconstitutional almost a century ago. But despite that, in many communities, including in the Bay Area, they were continued to be enforced against black people. Now, black families that dared to defy these racist rules faced violent intimidation. One family that did resist was Wilbur and Boris Gary and their 7 children. They moved to an all-white neighborhood in Richmond in 1952. And as soon as they moved in, they were greeted by a mob, which threw rocks, burned a cross, threatened to burn their house down. Now, my grandmother, who was part of a group called the Civil Rights Congress, rushed to the scene to defend the Garys against the mob. And eventually they recruited a group of over 100 supporters to form a humanitarian chain encircling the house. And they kept the mob at bay. But anti-black violence emerged elsewhere. Someone threw a brick into the store window of black realtor Netha Williams, who had sold the Garys their house. Here's a picture of Ms. Williams, the realtor, and she's showing the broken window to my grandmother there on the left. Now, the Garys eventually overcame the mob, but housing discrimination in Oakland continued. The city's leading newspaper ran whites-only real estate listings into the 1960s. Now, my grandmother had a front row seat as an activist in this racist housing market. But as a white woman, her own journey to home ownership was smooth and without incident. She and my grandfather bought a house in the late 1940s. It gained value over time, and they were eventually able to help my mother purchase a house of her own. On my father's side is a different story. My dad's family has been in this country since before the Civil War. The details remain murky. Like many black families, we're still struggling to find the records of our enslaved ancestors. But we have been able to trace one branch to enslaved people in Virginia in the 1840s. They saw none of the wealth that their labor created. The family later moved from Virginia to Mississippi, where my great-grandparents grew cotton and corn, earning just enough to survive. Their children fled the South during the Great Migration, including my grandmother, my father's mother, Octavia Rufus, who moved to Chicago. She arrived north in the 1920s and soon after met and married my grandfather. Chicago's housing market was just as discriminatory as the Bay Area's. Many of you, I suspect, have read Ta-Nehisi Coates' article on reparations. If you have, you will remember that he used Chicago as a case study for how racism in the housing market worked to inhibit and destroy black wealth. Chicago's racism led Dr. Martin Luther King to remark, "I have never seen, even in Mississippi and Alabama, mobs as hateful as I've seen here in Chicago." So banned from the city's north and west sides, my grandparents' only housing option was the segregated south side, with low real estate values, poorly funded schools, towering housing projects. They also faced discrimination in the job market, could not find jobs that matched their ability level. As a result, my father's parents were never able to afford a home. They never developed any equity to pass along to him. So like the presence of wealth, its absence passes down through generations. My father was never able to buy property. So who helped me buy the house? My mother, because she could tap into equity that was developed across generations. My dad, by contrast, relied on me as he aged to help him with things like groceries and rent. I used to think that my story was unique. But as I began sharing it with more mixed race people, over and over I heard similar stories from them. Children receiving financial support from the white branch of our family and providing it to our black relatives. We are, as mixed race black people, in some ways a living manifestation of the tables and the books like black wealth, white wealth. We embody the racial wealth gap. Okay, so what does this understanding mean for an access and opportunity-oriented admissions agenda? Well, I think because wealth is more powerful than income in determining a child's trajectory, because it's a better measure of disadvantage, I propose that schools begin to focus on it and focus on recruiting and admitting students from low wealth backgrounds. These are the students that have overcome the greatest hurdles, and they are the ones that will provide a perspective that is lacking on many college campuses. Now, this preference will disproportionately benefit black families for all of the reasons I just discussed. But it's not a racial classification, so it fits the test that Justice Scalia and the Supreme Court majority has laid out. And though it will benefit black families disproportionately, it won't benefit them exclusively, and it won't benefit them equally. That is to say, low wealth black families will benefit and high wealth black families won't. But there will be low wealth applicants of all races, including the children of delivery drivers, home health aides, restaurant servers, housekeepers, stock clerks, cashiers, call center workers. How many times at Harvard or at Yale have you talked to somebody about what their family did and somebody listed those occupations? There will be those of all races. And I believe that providing opportunity to low wealth students of all races is, in my view, a virtue of the proposal, not a defect. Now, some people say, well, this idea is untenable. I mean, we measure income because it's on our tax returns, right? But they say, well, how can we measure wealth? I don't think it's as hard as it looks. I don't think it's hard at all. Remember, what is wealth? A combination of a family's bank account, including retirement savings, and the value of their home. I'm not going to call on anybody today. I made that mistake yesterday. But I would tell you right now that if you are employed in this room, I suspect that if I pressed you, you could give me a decent estimate of those numbers right now on the spot. But even if you couldn't, those numbers aren't hard to find. You'd be able to get them at home on your computer in half an hour. And in fact, most colleges, including private selective colleges, require this information already in the profile that they use for financial aid. I see people with kids in college who are nodding. Like, yeah, I had to document that. So the only difference is my proposal would look at this information during the admissions process as well in order to boost those with the least wealth. So honestly, I don't believe this is a question of feasibility. I think it's a question of will. I ended yesterday's lecture by sharing with you the words of one of our fellows in the Access to Law program. And I want to close today with another. You know, I live in a city in which Connecticut's poorest neighborhoods abut one of the world's wealthiest universities. By the way, these are my words, not my fellow's words. I'm going to play a video with my fellow in 1 second. But I'm just going to tell you myself, I see this. I live in this city, these wealthy neighborhoods abutting, these poor neighborhoods abutting this wealthy university. And so as a result, I'm confronted daily by the legacy of American racism and the structural disinvestment in our urban core. At the same time, because I work in those neighborhoods, I'm also reminded of the rich human potential that no amount of discrimination has been able to destroy. And because I'm part of a program that's devoted to developing that potential, I have witnessed what can happen when we open doors that for too long have been slammed shut. So one of our fellows who I'm going to introduce you to in this video, named Babs Rawls-Ivy, she lives less than a mile from Yale's campus. Her parents were laborers who didn't finish high school. Her father left school in the 5th grade. She attended underfunded and de facto segregated schools in the 1970s that did not view a black girl like her as college material. Her high school was a technical school designed to prepare graduates for trades, not universities. Yet, by force of will, she became the first person in her family to attend college. And today, she is a brilliant, passionate community advocate. She wants to bring that advocacy to law. Here she is explaining why in a short excerpt from her law school application essay.
Hi, I'm Babs Rawls-Ivy. I am an Access to Law School Fellow, and this is an excerpt of my personal statement on my porch. I am a resident of New Hallville, one of the most impoverished and heavily policed neighborhoods in New Haven, Connecticut. Despite its struggles, I hold a deep appreciation for the resilience and vibrancy of the community I call home, and for the unmatched hospitality of the people here. This is likely the reason why I invited all kinds of people from all walks of life to visit with me on my porch. What started out as a series of social gatherings where folks would come to sit for a spell quickly became an open invitation for people to ask questions and gain insight into serious, often legal matters. In this way, the porch became its own community hub. Not long after I began helping people find affordable legal representation, I found myself bearing witness to the fear and anxiety endured by the families of those who have been incarcerated. While I've done my best to address these needs, the more complex legal matters require the expertise, experience, and resources that come with a law degree. Yet there are too few attorneys in my community to meet those needs. I want to be a lawyer to help close these gaps alongside pro bono attorneys, public defenders, and legal aid organizations. Before I was an advocate for my neighbors, I was an advocate for those with whom I had been incarcerated at Danbury Federal Prison Camp. It was during my time at Danbury that an unexpected call to service was revealed. As news spread that I was well educated, many of the women looked to me for help, reading letters from their loved ones. I oftentimes found myself in the library sifting through letters and writing responses on their behalf. My ability to read and write mattered even more because I shared a cultural identity with many of these women. And it wasn't lost on me that when they looked at me, they also saw themselves. For me, going to law school is about bringing legal training to the porch. I want to continue to be a friendly neighbor and a welcoming ear, and I also want to act as counsel for those who may not otherwise be able to access or afford assistance. When the time comes, I want to hang a shingle from the porch that says, "The lawyer is in."
So my hope is that in the years to come, you will work with me in developing a new language so that we can create new policies and programs to create opportunities for people like Babs. I think that our future, our nation, and our democracy depend on it. And with that, I'm going to invite Professor Natapoff.
Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon.
I'm not doing this by myself. It's an honor to be here in this important conversation. James, thank you so much for including me. My deepest thanks to the Tanner Lectures and all the organizers and staff who make it possible. I believe that these lectures are officially titled Universities and the American Dream. But to my ear, they have a subtitle, which is Resistance to Inequality. Racial inequality, class inequality, inequalities of wealth and opportunity, and individual flourishing. The United States, of course, is one of the most unequal democracies on the planet, getting more so. And so one of the reasons that these two lectures, yesterday and today, and Professor Forman's work are so important is that the university, and more broadly our educational system, sits squarely in the middle of this world of inequality, exacerbating it, doubling down on it, and yet at the same time holding out this tantalizing promise of easing it. I'd also like to take a moment to appreciate Professor Forman's willingness to get personal. In his lecture yesterday as well as today, he shared so much about his personal journey, his commitments, how they led him to do this work, and all the work that he does. And I don't think we emphasize enough just how personal these things are. Lawyering is personal. Education, learning, working, these are all personal. And part of the enormous wealth that a place like Harvard University confers upon its membership, faculty as well as students, is the personal engagement, satisfaction, and growth that it permits us all to engage in. At the law school where I teach, my students are not just studying to get a job. They're acquiring tools to live more fully, to express themselves, to contribute to the world intellectually, ethically, morally, culturally, all of it personal. And that, to my mind, is a truly extraordinary form of wealth that needs to be more equally distributed. So I'd like to zero in now on Professor Forman's insights about how we can make universities look more like America so that these forms of wealth can be distributed in a more egalitarian way. And as you just heard, he gives us two big ideas. First, a preference, a university admissions preference for low opportunity neighborhoods and zip codes. And second, a preference for families with low wealth, for low wealth families. Now, to be sure, he offers them in part as a response to the Supreme Court's decision to gut race-based affirmative action. But as you heard, the proposals are much deeper than that. They're not just a legal patch. They're not just a fix for a broken program. And they are not just strong proxies for race, although they are, of course, indeed, very strong proxies for race. But they're also a profound commitment in their own right to expanding educational opportunity to the millions of Americans who have been shut out of this form of wealth. Okay, low opportunity neighborhoods and low family wealth. And notice what else these two phenomena are. They're also the exact same criteria that most strongly predict overcriminalization. The American criminal system disproportionately polices, prosecutes, and punishes people in low opportunity zip codes and neighborhoods, and it disproportionately goes after people who lack family wealth and resources. We might even say something like, the criminal system already has a preference for low opportunity neighborhoods and low family wealth. And the criminal system has these destructive preferences for exactly the same reasons that our education system should have these preferences, because they are symptoms They're symptoms of historic residential segregation, of over-policing, the lack of jobs and social infrastructure, underperforming schools. In other words, we need our education system to catch up to the reality of inequality that is already embodied in our criminal system. So in these ways, education and the criminal system, they're flip sides of the same coin. They are Janus-faced, and they are inextricable. The criminal system, among other things, affirmatively worsens educational inequality, in part because it makes it so difficult, sometimes literally legally impossible, for people who have been touched by the criminal system to get an education. Conversely, education is a counterweight to the criminal system. It is the inclusive response to disadvantage rather than the punitive one. That inextricable relationship between criminal law and education also is, it in many ways explains this conversation that we're having today. It's not a coincidence that both Professor Forman and I previously served as public defenders, that we both write about race and inequality in the criminal system, and also at the same time, we both work to open up educational opportunities. And this congruence, this tight connection, it isn't always obvious, even to me. When James invited me to be part of this conversation, I was honored, but I said, I don't write about education law. His response was basically, yeah, you do. And of course, he was right. So I want to end, because I want to have as much time for conversation as possible, but I do want to end with a suggestion, another way of thinking about how we might respond to the inequalities and injustices that flow from these many exclusions. And so for those of you who heard the lecture yesterday and by reference today, when Professor Forman and his students created this extraordinary access to law school program in New Haven to bring more people into law school, notice what they didn't do. They did not sit in a room at Yale and wait for people to show up on their doorstep. They went into the community, they knocked on doors, they reached out, and they invited people in. And they did this not only to spread the word, but because they understood that inclusion itself requires a kind of education. That without more information, many people in New Haven would not have realized, they would not have understood that such a program could be for them, that they could thrive and succeed in such an environment. It turns out that requires some teaching. And so I think that the lesson for the rest of the academy is that it's not enough to sit in our offices, and maybe even in our classrooms. We need to get better at reaching out and sharing to show and teach more people that this is also for them. If there's time in the Q&A, I hope we can talk more about what I think we both think about what the possibilities for greater sharing is. But again, I want to get as much time in for conversation as possible, so let's get started. Thank you.
Yeah, did you put it on there? Because I didn't. Okay. Yeah. Thank you.
Hi, James.
Hi, Sasha.
Great to see you. Thank you so much for coming and visiting us at Harvard.
Glad to be here.
So, we've been in some version of this conversation for many years, but I just wanted to nudge you to share a little bit more of your insights about this relationship between education, criminal law, and civil rights. And in some ways, your work life is kind of a poster child for those relationships. You've been a public defender. and you started schools. You have been a civil rights advocate, but also a criminal justice scholar. And so just to continue that thread, how do you make sense in your own mind of the relationships between these spaces that sometimes people think of as being separate?
Yeah, I'm really glad you asked that, and I think it's such an important question. I guess for me, I'll say the connection or the relationship for me was not something that I formed. Like it wasn't formed intellectually. Like I'll give a sort of a theory kind of answer for the connection, and you gave your own theory answer. But for me, it grew out of working directly with people. So I decided to become a public defender because, to my mind, and this is the 1990s, when I looked at the civil rights work that my parents had done and that their generation had done, I saw a number of ways in which life had become more equal for Black people than it was under Jim Crow. Not nearly equal enough, but more equal. I saw a progress story. And then I saw our criminal system, where it seemed that things had gotten demonstrably worse, right? Where a Black man that is born in my generation, and this is from research from Bruce Western, formerly here at Harvard. He was here at Harvard. I don't know if he still is or not. He's not. Okay, so formerly at Harvard. So what he showed was that a Black man of my generation was more likely to go to prison in his lifetime than a Black man of my father's generation, which again, to me that just really blew my mind. So I decided I want to become a public defender because it seemed to me that the criminal system was the place to fight. The criminal system was the place to put your body to try to resist this growing inequality. And then when I was there, I loved being a public defender. It's the greatest job I've ever had. And I've loved jobs since I was a youth soccer referee at age 15 to being a professor now. I feel like I've been blessed with incredible jobs my whole life. But probably my favorite of them all was being a public defender. And when I was in juvenile court, what I saw was that so many of my clients, even after we had a successful outcome, that is to say, the case got dismissed, ideally, or maybe less successful but still good, was they got probation. So they were back at home, they were in their community, but they were back in a situation that wasn't good. It was better than the alternative, which was juvenile prison and juvenile incarceration, but it still wasn't good. And so I talked to my clients and I would say to them, like, what is it going to take for you to not be my client again? Like, I love you, like, let's spend time together, like, we can have coffee, I want to see you, like, at the movie theater, but, like, not in the courthouse. What's that going to take for me never to see you here again? And over again, they would say, Mr. Forman, like, a school. Like, I need a good school and I need a job. I heard that. School, job, school, job. And so that's when I sat down with David Domenici, and we really started to then try to brainstorm something that would meet that need that we were hearing from my clients. And that started as an after-school program, was good, but we still weren't doing enough. And then eventually we turned that into a school. So at that point in time, I was now, like, people were starting to treat me like somebody who knew something about the criminal system and the education system, and they were starting to ask me this question. They were like, oh, that's like an interesting combination that you're like doing those two things. And I was like so confused by that question, because to me it seemed obvious that I would be doing those two things because those were the things that I was seeing in my clients' lives that they needed. And so then I started to like try to have an answer, which is to explain it, which is shorter than the answer that I just gave y'all. And I said, look, there are, like, I believe in the state. I believe in government. I believe, like, I was raised, my dad talked about like what it was like to live in a world where you could never count on the government, where the state was either absent or your enemy. And part of what the civil rights struggle is about is making the state work for black communities. It's not the whole thing that it's about, but that's part of what it's about. So I want the state to deliver on what it owes and what is promised. And two institutions, in my mind, the two main ones, we can talk about others, family services, but in my mind at the time, the two main ones that I saw were the criminal system through the police and the education system through schools. And those were the two places where the government had its was acting in, or sometimes overacting, sometimes not acting, sometimes acting brutally inappropriately, sometimes acting negligently. But like, these were places where that were touching the lives and the future of black children in particular. And my belief is I wanted to devote my life to try to make those institutions be as fair and just and moral and responsive as possible. And so for me, that's like the connection between the two systems.
Well, thank you. I just want to highlight a piece of that story that I think is so profound, and sometimes, especially in the law school, it escapes our students that it isn't enough what you read on paper, that sometimes you have to go, you have to see it, that the experience of working in these spaces is literally revelatory. Mm-hmm. And I went to law school to be a civil rights attorney. It never occurred to me to be a public defender. I went to Baltimore to do civil rights work. And when I talked about housing discrimination, the people I was working with, they wanted to talk about the police. And when I talked about job employment discrimination, they wanted to talk about how their brushes with the criminal system were preventing them from being employed. And so I, through that work, they and Baltimore taught me that I had just gotten the labels wrong. I had thought that civil rights was something different than the criminal system, and when I saw how it worked on the ground, I took a little longer than you did, but I came around to understand that they were indeed the flip sides of the same coin. I want to make sure that we get a chance to answer some questions. Would anybody like to offer? Professor Steicher?
Well, you didn't call on me, James, so I'm gonna raise my hand. I'm very moved by your presentation, both of yours. Thank you so much. But I'm going to ask a skeptical question as a denizen of higher ed. And the skeptical question comes from a place of finances. Mm-hmm. So, you know, that stunning chart that you showed yesterday and today about how 67% of people at, you know, law schools are from the top 10%. Mm-hmm. I mean, one of the reasons is not just that, you know, people with high incomes and wealth are able to access better educations and put together better resumes and therefore be more attractive to higher ed. They're also attractive to higher ed because they subsidize the lower income people who come. Like, the rich people pay full freight, and the less rich people pay less full freight. Mm-hmm. And people may or may not know this, but it's true about Harvard and true about most universities, tuition does not fully pay the cost of higher ed. So that the money that, keeps the lights on and the labs open and pays faculty salaries also comes from payout, yearly payout from endowments. So you might say, okay, well, if we give up all the rich people, we can just, like Harvard has what, $50 million or however much it is in its endowment. But if you start spending down the endowment year after year, we're no longer going to be Harvard. We're no longer going to be able to have all the opportunities and the buildings and the labs and the, world-class faculty that we pay for right now out of a combination of endowment income and wealthy people. So where's the money going to come from? That's my question.
Yeah. No, it's a great question. And I don't mean to suggest that I think that universities can do it alone. I think that universities, especially wealthy universities, can do more than they're doing right now. And I think that, you're at the wealthiest university of America, I'm at the second wealthiest, and there's cuts, there's stuff that can be reduced, and money that can be reapportioned. There's a lot of luxury that is at a level that I don't think it needs to be for the university to fulfill its mission. Having said that, that's only going to get you so far. This is where I think, we didn't have time to talk about it, but this is where I think we need to broaden the conversation to talk about this as my framing is within the university. But really, what I want to be talking about is a broader social movement that is going to talk about getting greater resources, including government resources, to support these institutions, in particular on this measure, in particular around financial aid, so that it's not coming directly out of the university itself in the way that it is now. Now that, at this point, you might be like, oh wow, okay, you really have to be an optimist if you're talking about more government support at a time when we're seeing so much less government support. But I really want to talk a little bit about why universities are vulnerable right now. Because I think the access and the accessibility is a huge part of that story. So obviously we're in this moment where we have this sort of faux populist, critique from the right that says, well, universities aren't for you anyway, so why should we be supporting you? Now, I'm saying it's faux populism because I don't think the Trump administration, I don't think J.D. Vance, who's a big proponent of this, in his speech, universities are the enemy. I don't think they have policies that, in fact, are advancing the working class and low-income communities that they claim to be speaking for. However, the fact that they're lying generally doesn't mean that there is not a core truth about at least one part of the critique, and that is the critique that these universities aren't for you. They're not wrong. They're not wrong when they say that. They're not wrong when they go to audiences and they say, why are we supporting these universities? When's the last time you had a kid that went to Harvard? Right? They go out and they say that. And this has been true for a long time. So I want you to bear with me on this one. But the older people in this room will remember Davy Crockett. So okay, even some students are laughing. Okay, so Davy Crockett, he becomes famous in the 1830s for fighting under Andrew Jackson in wars against Native American. He's sort of the frontier ethos of America. Manifest Destiny is embodied in this Davy Crockett. He then is elected to Congress, He goes to Congress and he represents Western Tennessee in Congress. And he ran on this populist, I'm for the working man, and this is working white people that he's talking about working class and in Western Tennessee. Now, the federal government, some representatives from Eastern Tennessee want to build a college. And they want to build a college in Western Tennessee. And they need land for it. And Davy Crockett gives this big speech. And he says, I'm not going to support this proposal to build this college. Why not? Because the squatters that I represent, they have never seen the inside of a college. Their children are never going to see the inside of that university. So why would we give up land for a thing that's not going to be for us? This has deep roots. And like I said, Harvard, and like I'll say at Yale, they're not wrong. They're not lying. These institutions aren't for them. So my point is, we can't begin to build a political movement that is going to do things like have robust federal and state financing to support access and accessibility if we're not providing any kind of access and accessibility. But I think the potential exists to flip it and to say, hey, we want to be part of a movement that is going to make that possible. But to do that, if we're going to do that, we can't have the thing that we are most known for and the thing that we most proudly proclaim is what a tiny percentage of people we accept every year. When if that's like your main claim, then it's not. You're not going to be able to. Why would anybody want to support you? They're not. They know they're not part of the 3% that got in. So I guess what I'm trying to say, Professor Steiker, is that I think you are correct right now on the terms in which you asked the question. But I really think we haven't appreciated like what early stages we're in right now. Like none of us were alive. I wasn't alive, and I don't remember what it was like in 1968 and 1969 when like people started talking about affirmative action. But I do know that there was 50 years of conversations and panels and lectures and writing to try to develop a language and a set of policies and a set of structures. And I feel like that's where we are now. We're in 1968 again, but we're not acting like it. And I guess what I want to say is I think that everything is on the table. And I want to think, and I want to dream, and I want to imagine, and I want to create, and I want to build political coalitions that assume those things are, that believe that those things are possible and work towards them.
I think we have time for one more question.
Oh.
Just one more.
Yeah, y'all can clap.
Professor Bell?
Oh, yay.
Hey, I'll keep this quick, and I think it's a good follow-on from the previous question. Thanks so much to both of you. I'm curious. Inclusion means not just opening the doors to the law school. It, of course, also means making law school truly receptive to those that it's opening the doors to. And so I'm wondering if you could say a little bit about making the law schools perhaps we teach at or other law schools truly receptive places to a wider swath of students so that when they come there, they can be successful and included and really benefit from the opportunity that law school provides?
Yeah, no, that's such an important question, and Professor Bell is my colleague and a treasured friend and colleague, and so this is a conversation we're now having publicly, a conversation that we often have ourselves. I think it's really, it's like all the things. So we have to be thinking about just even in a way to do what I was saying before about going back to even the late 1960s and early 1970s, which was because that was really the first time that this conversation happened, right? Because that was the first moment when all of these institutions began to accept large or larger numbers of black folks and other folks of color, and they arrived and they were like, you know, what is this, right? And so there was protests and building takeovers and demands, and there were a lot of things that grew out of that. I think that when, you know, there's a bunch of pieces to it, but faculty composition and faculty commitments, I think to me is number one on the list. When students come to a university, what they're coming for is in part to be with each other and in a community, and in part to be with, you know, the institution. I mean, yesterday I talked about like the pure joy that I felt the first time I walked into a library at Brown. I had never been in a space like that before. I didn't appreciate that there could be an environment in which books were venerated in that way. My high school library was, you know, I went there for lunch just because it was quiet, but it wasn't like a place that you really wanted to be. And so people come for their peers, they come for the institution, but they principally come for to be taught. And that means a few things. It means faculty composition. And now I'm thinking about faculty composition again. I want to push deeper than some of the surface dynamics that we talk about. That's one of the reasons why I'm trying to have this conversation. That's one of the reasons why I want to have this conversation about wealth. And I want to have this conversation about disadvantage. Because we have to go deeper when we think about, well, what does it mean then to have a faculty that's representative of the nation and that looks like the nation? That means you want to try to have people who both have some shared background with these students that you're bringing in, but also commitments, separate and apart from background. It's like, what do you understand your job to be as a professor? One of the things that I find to be the most tragic about teaching in a law school is how completely sidelined and footnoted any conversation is about teaching. And it's shocking when I talk to students about this. You know, when we hire somebody, we'll have like a 5-hour meeting about all of their articles, and then there'll be like 2-minute read off thing that nobody ever asked any question about their like teaching evaluations. It's like, well, they taught this, they're teaching about it, and then we're done. And then we go back to talking about the article. And so to me, a big part of what we are teachers. And so I want to be hiring people that see that as a central commitment. Well, that of course then it's tied to, that's why this to me stems from the university mission. Because the university if the university has this as its mission, then it privileges and rewards people who invest in being teachers, right? It doesn't say, well, we want you to be an excellent teacher, but actually the only way you're going to get hired and tenured and promoted is based on your articles, right? So it's instructors, it's also the physical plant and the physical space. Bennett, I encourage y'all to look. Bennett Capers has a lovely article called Law School as a White Space. And in the article, he's building off of Professor Eli Anderson's idea of white spaces. But in the article, the last third of the article, he tries to reimagine the physical plant of the law school in a law school that is the kind of welcoming and inclusive law school that Professor Bell is asking about. So I would encourage people to take a look at that, to ask about, well, what are the portraits that we have on the building? And how are members of the community excluded from the space? I understand that we live in a world of security concerns that are different than they were 20 and 30 and 40 years ago. But it makes me weep every single time I talk to somebody who is from New Haven, who is born in New Haven, who is a working class black person in New Haven, who says, I've never been on Yale's campus. I don't feel welcome. I don't feel invited. And we structure everything at the university to exclude everybody who's not us. We send that message, and that message is received. So part of it is also attending to things like that. So look, I could keep going on this, and please come up and talk to me more if you want to about this particular question, because I think there are so many pieces of it. But those are the first few that I would say are faculty, the welcoming community, and the physical structure and physical plan.
Unfortunately, we're out of time, so we'll thank Professor Forman.